on fairly short notice. Also good to see Stephanie, one of the mods that are here. Jean Karras is from Colorado. I normally start off with a sort of extended greeting. I'm going to start off now by just kind of going into this, and then after a couple of minutes, I will engage with you guys again. So it's finally official, with less than 3 weeks to go to the trial date announced in September last year. The Morphew murder trial has finally been confirmed. It's the final legal hurdle in a criminal trial sort of go for launch sequence. And in a case that has seen the court venue change, the original judge removed, remember Judge Murphy was taken off, trial dates chopping and changing, multiple prosecution experts dismissed or their status altered, the lead detective thrown off the case, there's that whole internal investigation, counsel for the prosecution itself sort of morphing, one prosecutor sort of leaving, another prosecutor taking his place. The prosecution itself becoming kind of a whipping boy, it's felt that way certainly for the in terms of the defense, kind of a whipping boy in terms of the defense, and then also you felt like the judge has also been whipping the prosecution. You didn't do this, you didn't do that, and it kind of feels like the prosecution's been on the back foot and the defense has been on the attack, almost like the opposite of what the reality is. The prosecution are attacking a person's innocence. That's what a trial is. It's one side saying, I think you're guilty of this. I'm accusing you. I'm attacking you. I'm leading evidence. And then the defense then defends those allegations. Now, of course, attack can be the best form of defense, which is exactly what it feels like has been happening so far from the defense, attacking the prosecution, attacking some of the people involved, attacking credibility, attacking protocol, criticizing wherever they can, leading exculpatory evidence, basically saying, this isn't even a murder trial, it's a missing persons case kind of thing. All sort of attacks and undermining the prosecution's case. And the reason is really so that the case doesn't actually get to the trial phase, so that the proper attack, we actually say, okay, now let's actually deal with the narrative, let's actually deal with what happened, so that is actually completely avoided, because then it does become the scenario of the prosecution basically leading evidence, talking about what Barry said, what Barry did, what the circumstances were, and then the defense having to explain that, right? And so it's easier to not even get to that point. So, it actually feels like getting to this point of it, like a murder trial, it's happening, it's on it's been greenlit. It feels like it's a major achievement, but actually it's almost, from my perspective, it's almost like non-negotiable. There had to have been a trial in this case. And the crazy thing is, it took a year to charge Barry, just a few days short of a year. So he was charged, I think it was the 5th or 6th of May. And then it's only going to trial a year after those charges were sort of officially filed. So it's taken 2 years since Suzanne Morphew disappeared, and she's still missing, to get this case into a courtroom. That's how long it's taken. Almost 2 years to the day. The trial is scheduled to start the 28th of April. I think that's more jury selection. It'll probably kick off properly in May, but basically almost on the 2-year anniversary. It's taken 2 years since Suzanne Morphew disappeared, 9th, 10th of May. And that's also something that's not clear. We don't know exactly when whatever happened to Suzanne happened to her. And it looks like whatever happened on that Saturday afternoon, right? So the final page of Judge Ramsey Lama's 20-page order dated Friday, April 8th, 2022, it came out on Friday, I think, afternoon, states plainly in black and white, the court concludes additional sanctions are not appropriate at this time in terms of the prosecution. However, this order will serve as the baseline for future orders related to discovery violations. The case is set for trial to begin on April 28th, 2022. So ordered this Friday, April 8th, 2022. And that is the final page. Now, I must say, reading the order, like going through 20 pages, it kind of just reads like the prosecution failed to do this, the prosecution are in trouble for that, and on and on and on and on. And you sort of like go page after page, like this isn't good, this isn't good, this isn't good. And then you get to the very last line of the 20-page order, like literally the very last line. The case is set for trial to begin on April 20th. That is really the bottom line. So despite these problems, despite these issues, which seem like serious problems and seem like serious issues, sort of like the bottom line is, well, it is going to trial. And that is really a victory for the prosecution, although it's not like this, if you read the affidavit, and all of us on this channel, we've gone through the affidavit through how many episodes? Over about 12, 13 episodes it's taken to go through those 129 pages. We've seen that it does look like there's a case to answer for. That's why it's going to trial, because there's a case to answer for. So we're going to go through this 20-page document step by step. I'm not sure if we'll go through all of it in this live stream. I want to speak kind of in general about certain things, just in terms of the legal process and where we are now, and then we'll kind of go into more detail. In general, I think it suffices to say that it feels like Barry Morphew's defense have the momentum right now. It feels like that legal counsel have their noses ahead. They are taking the initiative. They are, making demands, and the judge is responding to them. It feels like that, and that they are the winners kind of going into trial. But in fact, a defense attorney quoted by the Denver Gazette went as far as to say, this is one of the most severe admonishments I've ever seen, talking about this 20-page order from Judge Lama that came out on Friday. He calls this one of the most severe admonishments I've ever seen, especially in a high-profile murder case. These are the words of the Denver defense attorney, Eric Faddis. As I say, I'm quoting from the Denver Gazette. And in his opinion, he says the rulings in this latest order have handcuffed the prosecution, and it's reshaped the entire case. He's basically saying what the defense have succeeded in doing is sort of, sending the prosecution into this trial with their hands behind their backs, handcuffed, and the whole case has sort of been altered in a way. And so in other words, from this defense attorney's perspective, it feels like the defense are going into trial with the upper hand, right? That's sort of his assessment of it. And then he goes on to share his expertise that maybe if they find Suzanne's body, the prosecution have a chance. So this defense attorney is kind of saying, you know what, this is like a slam dunk for the defense. The prosecution have been nailed again and again and again. And he says the following as well. He says, the case is on shaky ground, but they might salvage it. They might somehow salvage something if they can find Suzanne's body. So if they find Suzanne's body during the trial, then maybe they'll have a case, kind of thing. And the converse is, if they don't find her body and the trial goes on, then they're going to lose, kind of thing. And then he goes on to say, not only would that prove that she died and perhaps how she died, but it could lend crucial DNA material that the state could then use in testing other physical evidence. Now, I've got to say, when I read that, I'm like, dude, did you read the affidavit? Like, did this guy read the 129-page affidavit like we did? Because he seems to be saying that this is a DNA case, right? He's saying, we've got to have a remains, otherwise you're not going to have a case. And, it's almost like no body, no crime. So if you find the body, you can prove it's a crime. If you can't find the body, you can't prove it's a crime. Well, that's not what happened in the Patrick Frazee case. In the Patrick Frazee case, there was no body. Patrick Frazee was nevertheless found guilty, right? The one caveat to that argument, to say this case is just like the Patrick Frazee case, the caveat to that is, in the Patrick Frazee case, you had a star witness. You had his mistress coming forward and basically spilling the beans, saying, I cleaned up the crime scene. I was there when they burnt the tote. He said this to me. He said that. This is where you'll find evidence, and they did. This is where you'll find that, and they did. On and on and on. And so she basically, was the major breakthrough that they were looking for. That they had their theories, but ultimately it was his mistress that basically, I don't want to say sold him down the river, but basically settled the case, right? Now, in this case, you don't have that. You don't have a sort of star witness, unless you consider that Barry himself is sort of a star witness in terms of, how can I put it, that Barry himself's own words are kind of like a star witness against himself, just in terms of his own statements being problematic. And we saw that when we examined that affidavit. Stephanie says they did find a tooth fragment, so that, it's like saying, did they find Kelsey Barrett's remains? They found a tooth fragment that they were able to say was the tooth of a human female. They weren't able to say it was Kelsey Barrett's tooth, but it could be inferred that it was. In this case, there's nothing like that. There's no tooth fragments. There's nothing. There's just really some odd behavior. There are cadaver dog alerts on Barry's bobcat, which even law enforcement seem to say is not, they're saying the bobcat's not relevant. Not quite sure what that's about. But what I'm trying to say is, although it's similar to the Patrick Frazee case in this whole no body, no crime scenario, the hurdle that the prosecution got to climb in the Morphew case is a lot harder and a lot higher than in the Morphew case. On the other hand, what the prosecution have in this case is quite a lot of metadata in terms of the movement of Barry's truck, in terms of the movement of Barry's phone, in terms of his phone going into airplane mode at odd instances, and then also something that's becoming a regular fixture in true crime, modern true crime, things like texts, SMSs, smartphone data, that is either locating you at a certain point, or that is revealing what you're thinking and saying on a certain date. It's time-stamped, revealing the actual dynamics going on. And unfortunately for Barry, it appears that in his attempt to delete some SMSs, we don't know this for a fact, it's in the affidavit, he appeared to be swiping to delete texts or whatever it was, and instead he actually took a photo, and he seemed to take a photo of some of the most vital, I think one or two texts were some of the most vital that you would almost imagine, it's like which text would you most want to not be seen? And so you had that text from May 6th saying, from Suzanne to him saying, I'm done. I could care less what you've been up to for the past couple of years. I'm paraphrasing. And then also saying, let's do this civilly. I know I'm not quoting it verbatim, but it's amounting to that. And that was the timing of that text and the tone of that text suggests like things had really come to a head. And the question is, hadn't they? Right? So that's my sort of opening spiel. I'm going to go into this a bit further, but there's feels like there's a similar vibe in this case to the Patrick Frazee case, where the defense are sort of saying, this isn't a murder case. There's no proof of murder, and you know what, Kelsey Bereth may just be out there, and she's, for whatever reason, she's choosing not to come forward. And so, kind of, does the same apply to Suzanne? Suzanne's not dead. She's out there somewhere. She's maybe on a desert island. Maybe she's sipping mojitos and just like, I'm done. I'm living the rest of my life, and I'm watching this from afar. And so all of this is happening, and she's volunteering not to come forward. She's just somewhere out there. And I must say, if you believe that, then it sort of feels like, have you not been paying attention? Do you not know what is going on in Suzanne's life leading up to May 9th and on May 9th? Do you not know what is going on between Suzanne and Barry long term? Do you not know what their dynamics were? Are you saying that the dynamics are completely irrelevant here? And so you really want to get to know these people in order to know what likely happened here. And that can be a bit of a problem, because you say, but that's character evidence, or that is, you know, that's your opinion of how someone is. And that's going to be a challenge from the prosecution to bring these individuals to life the way they really are. You know, who was Suzanne really? Is she the bad guy in the story? Is she the bad guy in the story because she had an affair? What kind of person is Barry? Is he the person that you see in the suit with his daughters walking arm in arm? Or is he, is there another side to Barry, right? And you can make that argument, but you've got to make it based on evidence, and your narrative has got to be compelling. So it's going to be, once again, the case of the best storyteller wins in a way, which kind of doesn't seem fair. So anyway, let's look at some of your comments here. Juicy Jules says, I can drive an hour away and see him in court if you need updates. That would be great, Juicy. It would be great to get some photos, some observations. One of the things when I've attended trial is you sort of look at what, well, my screen seems to be buffering. Are you guys seeing me okay? My phone doesn't show me buffering, but my other screen does. So anyway, when I sit in court, I've attended a couple of trials. You really want to watch the person that's on trial like a hawk. What's their reaction when certain issues come up? You know, when do they look at the ground? When do they smile? When do they laugh? When do they look at the jury? When within a particular context? And some of those observations are really very, very interesting. There's some cases where certain evidence is led and the person on trial will show absolutely no emotion. And that absence of emotion can actually be a problem in the sense of, like, you would imagine that they should show emotion. A good example is when they sentenced. You can imagine if you are on trial and you've been sentenced, and it's like you're going to, you know, you must spend 20 years in jail, and you don't show any emotion. Well, you're trying not to show emotion. I can tell you right now, you are feeling emotional. But the other areas in a trial scenario where evidence is led that you can expect someone's going to gulp, that they're going to be really nervous about a particular thing, and that doesn't reflect very well on them. And are they showing emotion or aren't they? And sometimes the emotion that is shown is kind of like a concession. Sometimes it's involuntary, sometimes it's voluntary. But one thing that I've found with court reporting is sometimes it's very dry, it's very it's factual, but you don't kind of get the sense of the dynamics between the narrative coming out and how the people in the court are actually feeling about it. So in that sense, I wouldn't mind being there and kind of reporting on it myself. So Stephanie says the trial starts April 28th. As far as I know, that's jury selection. The trial proper, I think, starts in early May, but I mean, I could be wrong. Brianna says Casey Anthony's emotions worked for her to the jury. Now, you remember that's also going on. The jury are going to be looking at the accused, right? Well, we said the accused in South Africa, it's the defendant in America. The jury are going to be looking at the accused. It's like somebody says something and you look at the accused, what's your reaction? And they're also going to be told, smile at the jury, be you know what I mean? Be kind of on friendly terms with the jury without necessarily hugging them, shaking their hands, or taking them out to dinner kind of thing. You had Jodi Arias looking at the jury. We all remember that. So that is a factor, and you kind of want to see also how the jury are responding. Is someone falling asleep? Is someone taking notes? Is someone shaking their head? Is someone sort of sighing or whatever? What is going on with that? And you can bet your boots basically that the lawyers are going to be looking at the jurors going, we've got this one's, as the trial is going on, we've got this juror seems to be on our side. This one we're not sure of. You know what I mean? They're going to be sort of doing a sort of like a statistical thing of, okay, this one we've got, that one we've got. Are we winning this argument as the trial's going on? So we can kind of do the same thing. So Stephanie says, is it in your mother's character to disappear? Jean Karras says, Nick's not going to Vegas. I actually need to put out a video just saying that was an April Fool's joke because so many people believed it. And also because I know some people are going to change their itinerary, change their airplane booking. And I certainly wouldn't want someone to go to book just to see me there and then I'm not there. And then it's like, wow, I'm so disappointed, and this was so expensive, and I was led to believe this, so I'm going to need to do that. Tiffy says, why wouldn't we believe it? Yeah, well, unfortunately, it's not a reality yet. We'll see. Mel Stiller says, I don't believe the judge is allowing journalists to take photos during the trial, but I could be wrong. Mel, I think you're right. The scenario in the Patrick Frazee case was the same thing, just no live streaming. There was literally 0 photos allowed kind of on the court premises, meaning you couldn't photograph people going in or out. And so that really, in terms of a high-profile case, that really brought the Frazee case down to kind of medium profile. It was sort of covered, but because you couldn't take any photos, it just changed the dynamic quite a lot. I don't think it's going to be that strict here. I don't know if it's going to be a case of you can't even film people going in and out. I think the reason why it was so strict with the Frazee case was because they'd made a deal with the mistress, and the mistress wanted to minimize publicity because she wants a life after the trial. And so I think it was a very strict censure and censoring of the media to facilitate the mistress coming forward. I think I seem to remember on the day that she actually came forward, there's like this long delay where I think she actually even kind of got cold feet. So in this case, I don't think the censorship is going to be as bad as the Frazee case, but I still think it's not going to be live streamed, and I think it's going to be somewhat, the coverage is going to be somewhat limited because of that. And I don't know, I've noticed that a fair amount of people who've been covering the Morphew case have just stopped, and I think some of that has got to do with fear of I don't know, fear of litigation, fear of, until now, it's like this case hasn't even been going to trial. It may not even go to trial. So if you make any kind of inferences, you could get into trouble. But now the case is officially going to trial. I was confident it would go to trial. Of course, if it didn't go to trial, you could actually find yourself in a little bit of trouble. And there've certainly been a couple of YouTubers who I think have been scared off by that sort of situation. Hey Jealousy says, deals, backroom whispers. Yeah. Amy Hall says, someone really fooled Nick, ? Not sure what that's about. So, I mean, there's one particular YouTuber who covered the Morphew case exhaustively and very well, and she doesn't seem to be covering it anymore. That may change, but I was kind of surprised. Even my patrons didn't contact me to say the case is on. I will normally get a, the fact that, I mean, I've only just found this out now. I was sleeping. It's now almost 4 o'clock in the morning. So I went to bed quite early, but this news actually came out on Friday, where I am at Sunday morning. So it's taken actually quite a while for me to get the Google alert and bring this news to you. But normally I would have heard about it much, much earlier by other creators or by my patrons or somebody letting me know. I did actually check Lauren Schaaf's Twitter, but I must have missed, maybe I checked it on Thursday. But it's kind of been just quite weird how even the Morphew case feels like it's not that high profile. And whether it is or whether it isn't, I'm interested in the case. I feel like it deserves our attention, and I feel like Suzanne deserves justice. Suzanne deserves her voice to be heard, and it's been teetering on the side of that the case may not even go to trial. So it's been quite a weird approach to this trial. I must say it's been a long time in coming. And I think what a lot of us are feeling are the sense of, we want a particular outcome. We want to feel that justice prevails. We want to feel that the case is heard, that someone is tried, that certain evidence is led, and that then leads to a reasonable result. We want to feel that things are, how can I put it, kind of in good hands, and that the right outcome is not assured, but that it is reasonable. And so, I mean, right now where we are in the world with what's going on in Ukraine and the pandemic and so on, this trial, in a way, is a way of testing our ability right now in terms of this particular set of circumstances. Can we argue over a certain reality and come to a decision at the end of that where we can say with conviction that is likely what happened? Are we able to discern reality? It's once again that test, and is that going to settle the matter of what happened to Suzanne Morphew? Suzanne Morphew's been missing for 2 years. Is this case going to sort of settle the matter to say this is likely what happened to her? And in a way that you and me and people in general are going to say, I think that is, I think that the outcome was just, and the outcome was justice, and the outcome was legal and lawful and right and judicious and all those things. And in a way, it kind of gives you confidence that people are held accountable, that good prevails over evil. And the bottom line is, it's not guaranteed. Justice is not guaranteed. Good prevailing over evil is not something you can just assume. You can hope for it, you can fight for it, and what we're about to see is whether that's going to happen. And so we'll see whether it does. Oh, Sunflower says, I tried to notify you my Friday afternoon. How did you do that? Was it a YouTube comment? I was a little bit off the radar, certainly yesterday, my Saturday. I was definitely a bit off the radar. I had a couple of things to do. Boy Mom says, what's happening in the case? Okay, so maybe I must get back to my narrative. Okay, so I'm going to just continue through this. It says, this is quoting also from the Denver Gazette. And so they quoted this defense attorney saying basically that it's a DNA case, or saying that, you know, if they get crucial DNA evidence, blah, 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 blah. I don't know, it just seems to me, have you read the affidavit? Because anyway, the Denver Gazette goes on to say, prosecutors say the last time Suzanne Morphew, 49, was known to be alive was just after 2 p.m., May 9, 2020. That was the proof of life photo. That was a selfie that she sent to her paramour, to the guy she was having an affair with, Jeff Libler. And she was sunbathing in her backyard, and she took a selfie, which she sent to him. And that's the last proof of life we have of Suzanne Morphew. After that, her phone went completely silent. She didn't answer any more messages. There was something like 59 messages between her and her boyfriend, her and Jeff. Something like 59 messages in 2 hours, and then suddenly they just stopped. And she would normally say good night to him every night, or good morning to him every morning. And then that didn't happen that night or the next morning either. The next day was Mother's Day. She didn't respond to any Mother's Day messages. The next day was also her best friend Sheila's daughter's wedding, and she was very involved in that and very looking forward to that. And she was going to watch the wedding sort of on a live stream, and she didn't do that either. Sheila also, I think, sent details about her daughter's wedding, you know, like later on Saturday, and Suzanne didn't respond to that either. So there's this sudden stopping of cell phone activity from Suzanne's cell phone, including her cell phone going into airplane mode. And then so there's these questions, who could have had access to her cell phone? There were also like these strange multiple friend requests on the day before I think she disappeared. So I think Friday night there were like something like 20 friend requests to men, and I think 3 of them were to Jeffs, to 3 different Jeffs, not Jeff Libler, but to Jeffs. And so in a weird way, if you were going to go and investigate this case, you'd be like, if she was having an affair, maybe we need to investigate these 20 Facebook friend requests. So in a way, it would make it harder to figure out what was going on, right? Because all of those 20 friend requests were kind of false leads. And the question is, did Suzanne make those friend requests? If you say no, then who did? And so, yeah, you already have potentially a kind of staging, right? the article goes on to say her husband of 25 years, so Barry and Suzanne were married for 25 years, arrived home from work half an hour after this proof of life photo was taken. So the facts of the case are, it's kind of common cause that about half an hour after Suzanne sent the selfie to her lover, her husband arrived home. And now the debate is, did he somehow find out about it? So didn't he find Suzanne sunbathing in the backyard and she's got her phone with her? Barry's kind of been working on that Saturday, and then he said something about he was shooting chipmunks, that at around that time he got his gun and he was shooting a chipmunk and this and that and the next thing. And that's where it gets quite weird. Barry's behavior and his movements seem to be a little bit odd. Or is it just a coincidence? Barry says they had a nice evening together. They barbecued, they had steaks, they ate it off the same plate, that was something that the investigators queried. So if you had a meal, didn't your wife have a plate? Because they only found one plate in the kitchen. So he said, no, we ate off the same plate. He said they had a wonderful night together, that they what do you call it? They, were together, they barbecued together, they had sex. And then the last thing he remembered was he didn't see her, but he heard her snoring. And then, and he described her as a sort of a lump in blankets or something like that. That was the last that he could remember. But when pressed, like, what's your last memory of Suzanne? He couldn't really answer it. They asked him this repeatedly. What's the last thing you remember of Suzanne? And he couldn't really answer the question. The other problem is, in his story about Saturday night, he sort of said that, we had a nice evening together and something about, I think he said Suzanne didn't drink that night and it was just a nice evening that they had together. The metadata seems to show that he was in and out of his truck throughout the night. So you've got this sort of weird, you kind of got to imagine, how do you line up the idea of Barry barbecuing and, you've got to sort of monitor the steaks. You don't want to burn them. You've got to know how the whole, what's going on there. And how do you sort of line that up, the barbecuing, with him kind of being in and out of his truck kind of constantly, sort of on Saturday afternoon and evening? And the other things to deal with as well, which you've already dealt with in the affidavit. So what law enforcement and the prosecution seem to be suggesting is that Barry arrived home at this time that Suzanne was actively kind of engaging with her lover. And, did Barry either find out? Did Barry see something? Did Barry hear something? Was there some kind of argument? Was there a scenario of Barry chasing after Suzanne? Barry was a hunter. He had lots of guns in his safe. And, did he use a tranquilizer dart gun? Did he use it on a deer or did he use it on her? Et cetera, et cetera, et cetera. And so just kind of to go back a step, you'd imagine from the way the case is shaped and from Faddis's description that the prosecution are on the back foot and they've got a snowflake's chance in hell in succeeding. But from another perspective, looking at the affidavit, you kind of got to also ask, is there an innocent explanation for these activities? Is there an innocent explanation for the Barry cell phone as well, going into airplane mode at this time and coming off? Is there an innocent explanation for Barry saying he was at the work site in Broomfield when I think the CCTV footage or something shows that he was actually in his hotel room he went to Broomfield ostensibly to do a job, but seemed to spend many, many hours in his hotel room. And so I think one of the things that comes through in the affidavit is he says something like, when he got the call that Suzanne was missing, he was at the job site. But as far as I understand, he was actually in his hotel room. So like discrepancies like that, one, on its own, one of those may seem like so, so what? Maybe, it's okay. You don't have to tell the truth about absolutely everything. It doesn't make you a murderer. But when you have one problem like that, and then another one, and another one, and another one, you start to wonder what's actually going on here. So, for example, Barry also didn't drive directly to Broomfield. So he's going to a job in Broomfield, but instead of driving there directly on early, very, very early Sunday morning, he first went kind of on a slight detour. And that detour appears to align with where Suzanne's bicycle and helmet were found. So in other words, this detour that he took, he says he took because he saw deer running across the road, very early in the morning. And but the point is, I think he initially said he drove straight to Broomfield, but then later on, it was established that from his vehicle's data that he'd actually gone, I think, east. And he'd gone east for a short way, and then I don't know whether he'd made a U-turn, or I'm not exactly sure exactly how he drove. So I hope the prosecution can animate this or just explain this in a way that is clear. It might be clear to them in their minds, but to someone who wasn't there, it's not that clear. It's like, so a little animation of how he should have driven would be good, and an animation of how he did drive would be quite good. And also the thing that was quite clever with with law enforcement was they did a measurement of the odometer readings that from, like if Barry had driven straight to the hotel in Broomfield, if he'd driven sort of straight there and I guess straight back and perhaps to the job site, I'm not quite sure how they did the calculation, but they found that there was this, according to them, there was a discrepancy, that there was additional driving that they sort of couldn't account for, and they asked Barry to account for it. Like, did you go straight there? And so it later emerged that he didn't drive straight there, that he sort of made this detour. And so now you've got the issue of this detour corresponds to the road where Suzanne's bicycle, but also the helmet were found. And so what does that mean, kind of thing? The defense argued that there was DNA of an unknown male, I think I'm not quite sure about this, I think on the bicycle seat. So there was Barry's, actually I don't want to talk too much about this because I don't have it in front of me, but I think the defense argue something along the lines that there was DNA on the bicycle seat, I think, of one unknown male or one unknown person, and then also DNA on the dashboard of Suzanne's Range Rover. We're going to deal with that in a moment. So they basically say, sorry, that's exculpatory evidence. That is our evidence that some individuals came up to the house, and it's like some unknown people came to the house, and then we don't really know what happened, but Suzanne's disappeared, and so you can't blame Barry. We don't know what happened, and so there's reasonable doubt and blah, blah, blah. And so although it's fairly interesting evidence, especially if you look at who some of the DNA evidence traces back to, when you actually identify those people, it's quite interesting. The problem with that argument is possibly, it's not like it's in Suzanne's Range Rover, and I mean, she went mountain biking. It's not like, the DNA is not inside the home. It's not inside the bedroom. It's not on a piece of clothing. It's not on the helmet. It's inside her vehicle. And then you kind of got to ask, is her vehicle part of the crime scene? Right? And it's a little bit like the Ramsey ransom note, where you want to argue about, maybe you found a fingerprint on the Ramsey ransom note, and then you say, but is this ransom note really part of the crime scene? In other words, is it helping you solve the crime, or is it actually taking you away? Is it actually a misdirection? And the bicycle is also the same thing. You can argue the police shouldn't have touched it, the police shouldn't have moved it, the police shouldn't have whatever, and they botched the entire investigation because they did that. But then if it's staged, and at some point Barry seemed to agree that it was staged, if the bicycle was staged, then how on earth do you sort of go down a stage thing and sort of make an argument when the whole point is that the stage thing is to take you away from what's really going on, right? And I often find that the defense succeed in this area where they take your focus into things like that. So if the John Benet Ramsey case went to trial, the defense, it would behove the defense to spend a lot of time on the ransom note and get the jury's attention on the foreign faction and who could have potentially written it besides the Ramseys and intruders and all that kind of thing. You want to take him down that sort of road. On the other hand, the prosecution need to sort of say, okay, we need to deal with this because it's part of the thing, but it's actually taking our attention away from the meat and potatoes of this case. They need to be quite explicit about that. Sue's F's, thanks for that. You are very much appreciated. Thank you from Washington. Thanks a lot for that. So I have said it's already a massive achievement that the case has gotten greenlit to go to trial. And that didn't happen by accident or happenstance. Barry's defense have worked hard to scupper the trial. If you've been paying attention to this, Barry's defense have been trying to get the case dismissed. There's not just been one motion, there have been several. And they've even argued that this isn't even a murder trial because Suzanne's merely missing. She may not even be dead. So where we are now with this order from Judge Lama is basically that he said, actually, no, it is a murder trial. The standard has been met in order to say we need to interrogate this in the proper legal way of a courtroom, and we do need to test whether something criminal took place here. Was she murdered? Was a suspect behaving suspiciously? Is he guilty, etc., etc.? So in that sense, they actually lost that argument. They were saying it's not even a murder trial. Suzanne's just missing, and she may not even be dead. The court seemed to be disagreeing with that, saying not necessarily that it is murder, but we've got enough reason to question whether it might be, and let's now have that argument. Let's test those questions in court. You can't say that there's not enough, and so you dismiss it out of hand. That seems to be the way that I sort of understand it. So they've tried to just say, it doesn't even meet the standard, and the court has said, actually, it does, and so that's why it's going forward. Barry's defense have actually been keen to avoid the case going to trial. I said that while we were going through the affidavit, would you actually want to present this particular evidence, this statement that Barry made? Would you want to quote it in court? And then now the ball is in the defense court to explain this. Why is there this inconsistency? Why did Barry say that? Why did Barry concede that? And now suddenly the momentum seems to shift in a way. So, as I say, they put in motion after motion, either arguing exculpatory evidence or investigators undermining their own case. Remember, you had the one investigator, I think it was Cale, saying, this is the worst decision we've ever made. And the way it was framed in the media was like, you know what, prosecuting Barry or charging Barry right now is the worst decision you'll ever make. And what he didn't mean you shouldn't charge him, he meant you shouldn't charge him right now, and then they didn't. They didn't mean you should not ever charge Barry. He just meant, but that was kind of the way that it was fielded in a sense. Felt a little bit like quoted out of context in terms of the media. I don't know whether the media didn't understand or they did it to sensationalize it, make your audience indignant. But they also criticized the prosecutor for not playing ball, for the prosecutors not being open or transparent with exculpatory evidence. Maybe it's not even exculpatory, meaning it is to some extent exculpatory. It is to some extent helping Barry, and the prosecution simply didn't provide it. So that was kind of the argument. One thing that is sort of quite interesting in a case like this is you'll have the defense insisting that the prosecution give them everything. So you've kind of got the situation where law enforcement, thanks a lot, Lynn Coleman, thanks for that, where law enforcement go to all this trouble. So something happens, law enforcement go to all this trouble to investigate, law enforcement go to all this trouble to ask questions, to interview, to examine evidence, to collect evidence, to sort of put this file together, right? They go to all this trouble. And then they finally reach a point where they say, okay, we've got enough. We've been working on this for a year. We've got enough. And now we need to take it to the next step. Now we need to prosecute, right? Now we're ready. And then what the defense do is they basically say, okay, give us everything. Give us everything you've got. All the work you've done, hand it over. We want to know absolutely everything that you know about this case. And that's referred to as the discovery, but it also goes beyond that. They might say, I want every single communication you've made regarding this case, meaning any text you've sent, any email you've sent, any communication. And so that's where it kind of gets quite sort of like quite a sort of a labor, quite a burden for the prosecution. It's like now, instead of continuing to prosecute the case, continuing to investigate the case, now I've got to investigate myself and try and find every single email I've ever sent. And it's not just one person, lots of people. And what if somewhere I said, wow, I'm so tired, this case is taking so much out of me. Maybe it's an email to your wife or an email to a colleague. Wow, I'm so tired, I just wish this would all be over with. Or, you know, I think this case is the worst thing I've ever done. It's just stressing me out so much that maybe I'm going to have a heart attack. And you sort of forthright about that. And now the defense can use that, and they can say, well, this guy's expressed some doubt about, you know, his conviction about the case, or this guy said he didn't really want to be involved in the case, or whatever it is. And so now all of that stuff now becomes part of what the defense are privy to, and they can go through all of that and try and find something somewhere that sort of casts a bad light on the prosecution. And bear in mind, you haven't even started investigating the case or arguing the case. Now you are kind of undermining the prosecution in various ways. And so one of the things they found is that Cahill, I think, am I right about that? Cahill was, let me just make sure because I don't want to defame anyone. CBI agent Joseph Cahill used to be the leading investigator, and I think he was internally investigated. I think there was a issue where he discharged his firearm. I think I'm not sure if he shot himself in the foot or his gun went off accidentally, but there was some problem, and then he was actually taken off the case. And so here, if you're the defense, here's the beginning where you can say, oh, we have a problem with the lead investigator. You know, is this lead investigator credible? You know, here's something we can argue. And so it doesn't look good. It doesn't look good if you have the lead detective taken off a case. It's like, what's that all about? So if you're an innocent party looking on in this, you say, oh, so the lead investigator, where is he? Oh, well, he's not really part of this. That's not a very good look. The optics of it don't really look good. And then it says here, he stepped down from the CBI on December 8th, 2 days before an internal affairs investigation involving an incident in which a personal weapon discharged, right? I'll put a link to this. I don't know if all of you have access to it, but I'll put a link to this in the chat. But if you think about it, it's actually kind of totally irrelevant to, it's not like the defense was saying Barry didn't do that, or Barry didn't say that, or that text that didn't happen, or whatever. They're kind of going completely beyond the ambit of the thing, and they're saying this dude, one of the law enforcement crew, in a totally separate incident, did something. It's totally separate. And now they're making that the focus of their investigation in terms of the defense. And you kind of got to argue, you kind of got to ask, why are they arguing about, it is a problem, it is an issue, but why are you going so far out of the merits of the case to make your point? Can't you make the point? Can't you just say, Barry's got an alibi? Can't you just say, Suzanne was actually seen in Colorado Springs on that day? She walked into a Walmart. Isn't there some like obvious way that you can just deal with it? So why are you dealing with it in these weird sort of exotic ways where you sort of go and you find this stuff, right? Stephanie says, can you go over the exact charges? Are you talking about what is in the 20-page order? Are you talking about that? Are you talking about the exact charges against Barry Morphew? Is that what you're asking about? Teresa Fountain says that's been settled, right? Yeah. So let's see if I can find the charges. I think they've been sort of changed, but I don't want to say them off the top of my head because it's quite serious to do that. So let me see if I can. So I'm reading from the Denver Post, and as I say, this is subject to possible change. So at the time that it was put up, Barry Morphew was charged with tampering with a human body. So this is dated the 17th of September 2021. This is when I think the original court date was put up. So Barry Morphew is charged with tampering with a human body, tampering with physical evidence, possession of a dangerous weapon, and attempting to influence a public servant. And then it said, Judge Murphy decided to unseal the arrest affidavit by noon Monday. I think he said the meat of this case has been heard by the public. So until this particular point, I don't think he'd been charged with murder. The charges were tampering with a human body, tampering with physical evidence, possession of a dangerous weapon, and attempting to influence a public servant. I'm still not quite sure what that refers to. I don't know whether that refers to the voting thing, or whether it refers to him when he speaks to law enforcement saying kind of over and over again, I don't know, let's just put it that way. I'm not quite sure what the influencing of a public servant refers to exactly. Those charges were then updated on the 2nd of March to or let's just say, I don't think they were updated on the 2nd of March, but by the 2nd of March, he was, I think, charged with murder. So I'm just trying to see what it says here. Attorneys, so this is quoting from NBS News. Attorneys for murder suspect Barry Morphew want charges dropped against their client who's accused of killing his wife and mother. Just trying to see where they say arrest of murder suspect Barry Morphew was worst decision. just trying to see where they say that the charges are of murder. I mean, Morpheus has been charged with first-degree murder. So this was the sort of update to those charges subsequent, and then all those others again: tampering with a deceased human body, tampering with physical evidence, possession of a dangerous weapon, and attempt to influence a public servant. Have I missed any charges? Quite interesting that there's not defeating the ends of justice or something like that, because if you would imagine in a scenario of a staged crime scene or cleaning up of a crime scene, or I'm just sort of wondering, is obstruction of justice irrelevant in the fabric of this case? Or is that within the field of tampering? I don't know. Heavenly Clouds, thanks very much for that. Teresa Fountain says voting fraud. I think so as well, but one thing I did notice Barry gave about 15 or 16 separate interviews to law enforcement, which in itself is incredible. I think that's the biggest asset to the prosecution in this case, those many disclosures. Of course, they've recorded what they think is important. Probably they had to hand over all the audio, and maybe Barry said other things that the defense can use, where may have made other reasonable, rational arguments. So who knows? But there seemed to also be kind of a sense of not collusion, but Barry kind of saying, I like you guys. I don't know, there was some statement where he'd said, you said you'd be my advocate. So I don't know whether you could argue it both ways, that they were trying to influence him or manipulate him. Maybe he was trying to manipulate them. But anyway, the question crossed my mind, was that the attempt to influence a public official? But I guess it is the voter fraud. I'm just saying that's something that crossed my mind. Was an attempt to influence the investigators while he was talking to them, and of course you would kind of say, of course he was trying to influence them in the sense of he's trying to convince them that he's innocent, or he's trying to, they're asking him questions and he's got to provide a story, a version that is acceptable or reasonable, or that's going to bolster or support his innocence. So of course he's trying to influence in that way, and they're trying to influence him in the way of that he will continue talking to them. And so anyway, the question just in my mind was, is this influence either way? Is it legally questionable? I'm just admitting to the thoughts that crossed my mind. Martina says, a charge like that doesn't come out of thin air. Stephanie says, I remember you from the Everest disaster discussions. Jeremy says, hi from the Netherlands. Good to have some dudes in chat. I think Raoul Thomas is also a dude. Ski resort at Monarch Pass. Is that where you're from? Anyway, Jeremy says, hi from the Netherlands. If I was in the jury, I would like to know how Barry did the tampering with the body, since the Bobcat was not used and cadaver dogs gave no hit in his truck, as I understand. So as I remember the affidavit, I think there were 3 cadaver alerts related to the bobcat. But then you have the problem that law enforcement seem to be a bit cagey about this, or seem to be a bit weird about this. They say something like, in their view, the bobcat's not relevant or related to the circumstances of the crime. So I just find that like odd. It's like it's like 1 step forward, 2 steps back kind of thing. So Jeremy says, if I was in the jury, I'd like to know how Barry did the tampering with the body. So and he says, since the bobcat was not used, I'm not convinced the bobcat wasn't used, but if it was used, the question is, how was it used? Where was it used? When was it used? All that kind of thing. One's also got to ask the question is, what are all those disposal visits about? So could that possibly be related to tampering with a human body, or is that totally separate? Like, is that was he disposing of clothing? Was he disposing of trash? Was he disposing of, what was he disposing of? Was there any sort of DNA or human remains related to that disposal? And that's quite a difficult question. I think the big question is, the question hanging over the whole case is, where is Suzanne Morphew? So no matter what happened to her, where is she? Where is some evidence of her? What evidence is there of her? And on the one hand, although it feels like this huge burden for the prosecution, I always say the absence of evidence is also evidence. So the fact that Suzanne's disappeared, missing, whatever, you could say it favors the defense, because you say, well, because we don't know exactly where she is, you can't say that this or that happened, and that, so there's doubt around the circumstances. But on the other hand, you could flip the whole thing around and you could say, who is the person closest to Suzanne? Who is the person who saw her last? Who is the person who should know or could know or would know what may have happened to Suzanne? And can you account for things like the state of your marriage and your movements and all that kind of thing? And so can you explain how she's disappeared? In other words, what's your story for why it makes sense that she's just completely disappeared and we've never heard from her again, right? And then your best witness for this is Barry. And so you ask Barry, what's your explanation for this absence of your wife? Why do you think your wife has disappeared? And then does he come up with a convincing argument? She often liked going for walks, and there was like mine dumps and mine shafts there. She went there every day, and maybe she fell in one. That wouldn't be a bad argument. She often liked to go to the most remote corners of the planet, like the North Pole and the Amazon and whatever, and then she just didn't come back. That would be quite a good explanation. But she didn't normally go mountain biking in the morning. In fact, she normally slept late. So what's the story there? Why didn't she take a water bottle when she went mountain biking? Right? Why is the way that the bicycle's fallen odd? I mean, that's something else. So just have a look at some of your questions. There's no one else who wanted, or is there anyone else who wanted to rid the world of Suzanne Morphew? So it's quite interesting, the intertextualities between the Barry Morphew case and the Chris Watts case. you also have this sort of claim that he had sex with her just before she disappears forever. It's like, the fact that I had sex with her means that we were happy, that we were in love, that she loved me, that I loved her, that everything was absolutely fine, and then she disappears and she's never really seen again. It's the same kind of claim from Chris Watts is, yeah, I had sex with my wife, kind of the last thing, and then I left for work. Barry says the same thing, then I left for work. In the Chris Watts case, the disposal is associated with him going to work. In the Barry Morphy case, the question is, was disposal associated with him going to work? But there's a difference here. There's a long period of time between like 2:30 on Saturday afternoon and Barry going wherever he went the next day. There are many hours. So what actually happened during that period? Also, Barry, I think, was at like a work site, I think in Salida, and apparently was working with machinery late at night. And the question is, how relevant is that? Is that relevant? What's that all about? And then, yeah, Suzanne's text messages certainly are interesting, an interesting narrative. Whether or not you look at Barry's, it's an interesting narrative. So just to continue, the defense have kind of been arguing that this case is a mess. The charges are flimsy, so just dismiss it. It's messy. The prosecution have messed up also. It's a flimsy case. It's a messy case. Just throw it out. And look at Barry. He's a well-dressed guy. He's innocent. His wife had the affair, not him. And look how his daughters still adore him. It's a weak case. Throw it out. And that's kind of how it's been going until now. And that hasn't really sort of worked. Is the case a mess? Well, the 129-page affidavit seems to show it's been thoroughly, carefully, meticulously, cleverly, strategically investigated, systematically investigated. Barry has said an awful lot in those many statements he gave. He's given a lot of information. And so the judge hasn't thrown it out. What the defense seem to have been arguing are all these different things. Not look at the 129-page affidavit. Let's ignore Barry's 15 or 16 statements. Let's ignore the conflicting statements within them. Let's not pay any attention to the bizarre metadata, the chasing of chipmunks on Saturday afternoon, the detours to watch deer, the phone going into airplane mode, the texts, the escalation of tensions and surveillance from the couple. And by that I mean the couple that are starting to perform surveillance on one another. Suzanne Morphy buys a spy pen to secretly record her husband. Barry, I think, is accused of, or the idea is that Barry put certain cameras. I'm not exactly sure what these cameras were. I don't know if it's motion detector cameras. My father's got exactly the same kind of camera. Or let me not put it that way. My father's got cameras that you can place in wild settings, in settings of nature, and they are triggered by the movements of animals. In other words, they'll be sort of in a dormant mode, but if a camera, I guess they're motion activated. And you don't actually know they're there. So in other words, they are placed in a tree or placed somewhere, and you don't actually know they're there. And it's in the same way that you can use these cameras to observe the movements of wild animals, and to, in that sense, you can also potentially eavesdrop on conversations and eavesdrop on or perform surveillance on a person. Barry also apparently had a manual for a video camera, but the camera itself was never found. That I found quite interesting. and so, but anyway, the issue was that there appeared to be one spouse spying on the other spouse, trying to sort of collect evidence, trying to collect information, trying to find out what was going on and who it was going on with. And then you had seemingly the same thing happening with the other spouse. The other spouse is also monitoring the other spouse, and there are different ways that seems to happen. The one spouse looks at the other spouse's phone. The one spouse seems to look at the other spouse's iPhone cloud. I don't know whether the one spouse had access to the other one's Facebook, but you have all these different things kind of going on. And the question is, what does that mean? Had things escalated to a point where it was dangerous? Had things escalated to a point where they were merely toxic? Or had things escalated to a point that it was merely their relationship just wasn't great anymore, but that's irrelevant? But then you kind of get problems in the affidavit that are harder to deal with, which is why you wouldn't want the case ready to go to trial. So things like the airplane mode going on and off at certain times. It reminds me a bit of the Amanda Knox case, where both her phone and Raffaele Celeste's phone go off at a certain time, and they're off the whole night. It's the night Meredith Kutch is murdered, and then they go on sort of the next morning. But that didn't happen previously. They didn't turn their phones off previously. So what's that all about? And I want to use the Amanda Knox case briefly as an analogy to this, because someone sent me video of her speaking, and I've written, I think, 5 books on Amanda Knox, and I would be very afraid and nervous if I was her speaking to a crowd, given a lot of the information that's out there. It would be like, how on earth do you make your case? And the answer is, well, I mean, you can tell by looking at it anyway. She doesn't go into a lot of detail. A lot of it is generalizations. She avoids going into some of the complexities. A lot of it is very sort of glossing over. And in a way, the narrative that she talks about is peripheral to the actual circumstances of the case. In other words, so that is quite a good way to defend your case, is you keep taking it out of the meat and potatoes of the case, and you keep taking it to peripheral things. So you keep, if I was the defense in the Morphy case, I would keep bringing it back to the bicycle, or perhaps the Facebook friend requests or something like that. If I was the defense in the Ramsey case, I would keep coming back to the ransom note, and just like, you know what I mean? Like, who is this foreign faction or whatever it is? So in terms of the Morphew case, when you go into the meat and potatoes of it, some problems come up. And here's an example. So you've got this escalation of tension. So that's the narrative that the prosecution want to clearly and compellingly sketch. They've got to anchor it in real text. They've got to anchor it in real time. They've got to anchor it in the voices of the people involved. They've got to key into the personalities of Barry and Suzanne. You've got to get the sense of what is really going on. And so they've got to have a real sense of who these people are. They've got to have, they need to have gotten to know them. I'm sure some of these investigators will have gotten to know Barry very, very well, but have you gotten to know Suzanne very, very well? Have you understood how she was quite a passive person, but she'd gotten to the point where she was now ready and willing and to some extent able to stand up to herself and for herself. And so, you in this context of escalating tensions and surveillance from the couple itself, the couple monitoring one another, and Barry's position was that he didn't know his wife was having an affair. He still doesn't know, or I don't know if it's still today, but in terms of the affidavit, it was like up until April 2021, he still didn't even know the name of the guy that she was having an affair with. And he didn't seem to be very interested. He wasn't really asking. He would ask here and there, but he didn't seem as interested as you might think. But then you have a problem like Barry saying to Morgan Gentile, allegedly, so it's basically what Morgan Gentile says that Barry said. Can you prove that? Also, is Morgan Gentile a credible witness, right? But this is in the affidavit, and obviously it's in there because law enforcement think that it's relevant and it's significant. This is from page 50 of the affidavit. And this happened on Saturday, according to Morgan Gentile. She was riding with Barry to a work site. So while Suzanne was flirting with Jeff, while she was texting him, I'm not sure if they were messaging on LinkedIn or exactly how that was playing out, but while Suzanne sort of sunbathing and relaxing and lounging and whatever, Barry's with a co-worker, quite a young brunette lady, and she's sort of his work colleague. She works for him in this instance, and somehow it's kind of quite bizarre. In the middle of this work day, she said something like, "Pigs can eat an entire human body in 2 hours." I don't know whether she got that from a Hannibal Lecter movie or something, but anyway, she made that statement. According to her, that is what she said. And then she said Barry responded to that volunteering of information by saying, quoting from page 50 of the affidavit, quote, "Barry commented that he would be able to bury a body and it would never be found," end quote. Now, on the one hand, that seems like really compelling, tough evidence to defend if you put it in a court setting. If the jury hears that, what the hell are they going to think about that? That Barry apparently said on the day that Suzanne disappeared, "I know how to bury a body and it'll never be found," or words to that effect. I'm kind of just paraphrasing. But he's, according to the affidavit, he said he would be able to bury a body and it would never be found. That's page 50 from the redacted affidavit. I think the defense would prefer not to go there, and with good reason. Imagine just the scenario. You know how to bury a body so it would never be found, only for someone close to you to then go missing. Well, now how do you account for that? On the one hand, you could say, so what? Someone can say a lot of funny things on a particular day. It's just words. It's not related. It's not relevant. It's a fragment. And also, can we really trust the person who's telling us this? Is it really true that Barry said that? It almost seems to be too good to be true. It almost seems like curated because it's so kind of perfect. Is it trustworthy? Did Barry really say this to Morgan Gentile? And that will be something you can bet will be an argument between the prosecution and her. And it'll be up to the jury to decide whether they believe her, whether they find her believable. But it certainly is quite an interesting context to all of this. And Patrick Frazee also said things like that. He said something like, "No body, no crime." And I think he said that prior to Kelsey Bereth disappearing, and then she disappeared. There's a saying, "Loose lips sink ships." So again, are we searching for a living person or a dead person? Is Suzanne Morphew dead or alive? What is likely? I think it's the same question in the Summer Wells case. Is Summer Wells alive or dead? Is Madeleine McCann alive or dead? And, I don't think it's rocket science to say the longer a person is missing with absolutely no evidence, the better, the more likely the possibility that they aren't alive. And I think it's quite insulting in a way to say Suzanne is actually out there and she's just not she's just not interested in participating or in clarifying what is actually going on. She hasn't contacted any of her friends, hasn't contacted the guy she was having an affair with, that she was in contact with every single day, or like sending multiple messages on the last day. Hasn't contacted her daughters, hasn't contacted her siblings, didn't contact her father while he was still alive, just dropped off the face of the earth. But there's an innocent explanation for that. She just simply kind of wants to be alone or something like that. So that's one possibility, that she just decided, nah, I'm done with this, and then just went off into the sunset and is out there somewhere. But the other explanation is she unwillingly lost her life. She fought for her life and lost her life, and her body no longer. There is no mind anymore. There is no heart. There is no person walking around. In other words, she's not choosing not to come forward. She isn't able to come forward because her life was taken from her forcefully, violently, horribly. Her life was taken away from her. Choices were taken from her. Everything was taken from her. So this idea that it's actually not a big deal, she's actually just a missing person, and she's choosing not to come forward. No. Her choices were taken away from her, all her choices. And I think there's quite a world of difference between the one version of that, the mildness of it, the euphemism of it, and frankly, I think it's quite insulting to say that, to suggest, you know what, there's nothing to worry about, nothing to see here. There shouldn't even be a murder trial. No, I think there should be a trial. I think there is a case to answer for, and I don't think it should be minimized. I think it should be, let's not dismiss this, and let's not be dismissive of this. Let's treat it properly and seriously and say, what does your husband say about this and that and that? How did Barry feel about the fact that his wife was having an affair? What kind of person is Barry? Was he the kind of person who would tolerate that in his wife? Why did Barry say over and over again that he thought that this was God's will? Whatever happened to Suzanne was God's will. So anyway, the bottom line is, despite all their efforts, Barry's defense failed at foiling the prosecution of this case. They failed at preventing it from going to trial with all of these motions. And one motion on the 9th of March, about a month ago, so not long ago, just a month ago, it was another attempt to dismiss the case, read, motion to dismiss based on presentation of false testimony at pre-trial hearings. I'm not going to read that motion, but the first line of it is, Mr. Morphy asked this court to dismiss all charges in this case. In Judge Lama's final order, the word exculpatory comes up 17 to 20 times. You know what exculpatory means, right? It's a legal term referring to evidence that exculpates, evidence that shows you didn't do it, evidence that tends to show you weren't involved or probably weren't involved or couldn't have done it. It's the opposite of inculpatory evidence, evidence that shows that you do look guilty, that looks like you did do something. Now, we'll deal with these 17 references, probably not in this live stream though. We'll deal with these 17 references to exculpatory, but the crucial reference in Judge Lama's order is the 13th reference, which is on page 17, near the very end of the document. Excuse me, that's the crucial the crucial reference to exculpatory of the 20 references. Sorry, of the 17 references. So hang on, let me just get this right. Sorry, there are 17 references. The 13th reference takes place on page 17. So I'm going to read it. So it goes like this. Somebody says, Elizabeth says, did we all hit the like button? I see there are 334 people in chat and only 200 likes. Come on, guys. Okay, so now we're on page 17 of 20 of this order from Judge Lama, and it deals with the Range Rover data, right? Can you anticipate what this is going to be about? Terry Dean says, put the girls on the stand and ask them if they believe their mother abandoned them to sip mojitos on the beach. Yeah. That is a very heartbreaking and sad and difficult area, is from the prosecution perspective, from the defense perspective, and also from their perspective, is what are they going to do? What are they going to say? What do they think? What do they really think? What are they being told to say? What are they feeling? What are they thinking? It's, if their father is found innocent, they've still lost their mother. Their father is found guilty, in a sense, they lose both parents, right? It's a pretty horrible situation for them to be in. Anyway, so this reference, this 13th reference to the word exculpatory on page 17 reads as follows. Range Rover data. The court finds, as it relates to the Range Rover data, that while the people have been dilatory in providing the data to the defense, quite an interesting word. I think it kind of means sort of vague, opaque, oblique, not specific enough. Let me look it up just to be, accurate. Dilatory. It's not a word you see very often, is it? It means slow to act. Oh, okay. I actually thought it's like the eyes that dilate. It's actually not. It's not what I said. Sorry about that. My bad. Dilatory means slow to act, unhurried, tardy, unpunctual, lax, slack, postponing, procrastinating, stalling, delaying, deferring, intended to cause delay. So so I actually feel pretty bad as a word scientist. I should know a word like that, and it's not got anything to do with being vague. It's got to do with being slow. So anyway, that's the wording of this finding. They say, while the people have been dilatory in providing the data to the defense, the court does not find said material is exculpatory. So in other words, the judge is basically saying, although it's true that the prosecution took too long, delayed, were slow in providing this evidence, the evidence that they did provide isn't actually exculpatory, right? So you had the defense arguing that, can you believe it, this exculpatory evidence that we've been waiting for, that the prosecution have been mischievously withholding from us. They've been sort of playing this game with us, and they haven't been giving it to us. And, this is exculpatory evidence. It's not acceptable, right? I'm paraphrasing, but it feels like that's sort of the way it's been, just being very sort of general and simplifying the argument, but kind of just saying, we arguing that this information that was crucial to our client, it could actually be exculpatory. It could prove, it could show that poor Barry's innocent. This essential, important, vital, crucial evidence has actually been withheld from us. It's been not provided to us. It's been, whatever you want to say. Well, ultimately, it was provided, but it took long. It was delayed. And the prosecution could argue either we didn't think it was material, and you could argue, well, no, it is important. But they could say, was it really that important? If it was important, I think if it was like super, super important, super relevant, the defense could say they withheld exculpatory evidence that's absolutely unacceptable. They knew our client was innocent and they withheld it, and that's just not right and wouldn't have been right. The judge is saying, we don't actually find this material is exculpatory. In other words, they're saying, I'm not saying that the court's saying it's not relevant, but they're saying it's not good enough evidence that you can say we can dismiss this case because it's such fantastic evidence. So that is a major finding there in terms of the Range Rover data. And it's referring to the DNA found, as far as I understand this, on the inside of the Range Rover, which is suggesting could other unknown males, or could other individuals have been involved in this? Could it be an intruder scenario? Could it be an abduction scenario? Could someone have come up to the house while Barry was in Broomfield or Barry was away and done something with Suzanne, taken her away? But the interesting thing with this whole scenario is, so they then staged the bike. So in other words, someone abducts Suzanne and they staged the bike anyway. So Suzanne didn't go for the bike ride and Suzanne was taken from her home. That's really interesting. Other things that are interesting are the burnt contents of the furnace, of the hearth. Like they found pieces of wood that weren't part of the kindling, and there was a huge amount of kindling that was out there. But also they found other things that it looked like it could have been a journal, I think. They found other things that were in the fireplace that appear to have recently been burned, which I think is quite interesting. Barry, I think, also made some kind of comment somewhere about chipmunks getting into the fireplace or something like that. I'm not 100% sure about that, but I seem to remember something about that just seemed odd. So anyway, so it says here, the court does not find said material is exculpatory at this juncture. On February 10, 2022, the court ordered disclosure of the Range Rover data by February 24, 2022 on the record. Court orders disclosure not later than 14 days from today's date. On February 24th, 2022, the defense made another request for the Range Rover data. The people provided a flash drive that same afternoon. On March 1, 2022, the defense contacted the FBI agent regarding the Range Rover data and so on and so on. So it's sort of an argument over some of the data. And the bottom line is the court didn't find this argument that the prosecution seemed to be withholding or slow to provide. They didn't really find it exculpatory. And I think this is a major victory for the prosecution, although I don't think it's rocket science either. I've made an assumption here. I haven't really read this document page by page, line by line. I've sort of skimmed through it. I've highlighted some of it. So I'm assuming that it's referring to the DNA. I don't know whether it's actually referring to the metadata. I don't know that for a fact. But I'm assuming that, let me just say the following. Finding someone's DNA somewhere in a crime scene as vast as this one. I'm talking about not Barry's DNA, not Suzanne's DNA, let's also say not the daughter's DNA. Finding someone else's DNA on a crime scene as vast as this one. And bear in mind, it includes the Morphew home near Salida. It includes the Bobcat. It includes the vehicles, multiple vehicles, but also Barry's vehicle. It includes a hotel room in Broomfield. And it includes much wild terrain between those locations. It includes probably, possibly, potentially disposal sites in between. It includes potentially, possibly the area where the bicycle is and where the helmet is. So it is a very big crime scene in terms of scale and distance. I don't think you can just say that the crime scene is the Morphew home. it's also the garden outside the home, the driveway, right, and then it's not just that; it's also Broomfield. It's also potentially other work sites, right? So it's quite a murky, muddy crime scene potentially. If you take the Chris Watts case, you have a crime scene that it's basically the Watts home, 2825 Saratoga. So that house is a crime scene. His truck is a crime scene, and because the truck gets transfers the crime from A to B, and B is Survey 319, and Survey 319 is a crime scene, right? So you have three relatively compact, what's the word? You can put crime scene tape around those three sort of areas, and that's it. But even in the Chris Watts case, there is arguably a fourth, I don't want to say crime scene, but a fourth area, and that is when he came back from Survey 319, he went to a dumpster, and that's part of the metadata as well, and he apparently threw, I don't know, blankets, kids' toys, or whatever, clothing or something, into the dumpster on Black Mesa, just around the corner from his home. So in this case, you have much more of that sort of thing. You've got Barry going to five different locations, like at the McDonald's, here, there, and somewhere else. And is that part of the crime scene? If so, how so? And that can make it a very big, wide crime scene, right? The other thing is, because Suzanne Morpheus' remains haven't been found, the crime scene is in a theoretical way it doesn't have an actual boundary. It's like we think the boundary is here, but we don't actually know. When you don't have the body, you can't determine things like cause of death, manner of death, even to some extent place of death, time of death, all those sort of things. And that can make things quite difficult. On the other hand, something that you have today that you didn't have necessarily 20, 30, 40 years ago is, although you may not have the human body being seen doing this and that, and suddenly it's in a certain location and it doesn't move anymore, you have something that someone carries with them everywhere, communicates constantly with, that suddenly goes dormant. Their phone, they are very active, they habitually do X, Y, and Z, and then that suddenly just stops completely. Their social security number is not used subsequently, credit cards are not used. And that's another aspect that I think is very interesting in the Morphew case, is Barry's use of the family funds, Barry's use of assets that actually belong to both of them in the time of Suzanne's disappearance. Barry liquidates the house. So the financial narrative, I think, is an important narrative that the prosecution needs to properly outline and also do so in a way where you line it up with Suzanne's story. In other words, how the financial narrative and Suzanne's narrative go hand in hand, because Suzanne inherited $500,000. And then look at how that relates to Barry. Did they talk about money in their arguments? Did they argue about money? What was Barry's financial narrative? Did Barry ever ask Suzanne for money? How much money did he borrow from her? And so on and so on and so on. And so that needs to be presented in a way that's relevant and compelling and significant, because often in true crime we see that money is a motive. Money is a motive for murder. I think it was Juan Martinez, who said, in his experience, it's quite simple, talking in terms of criminal trials and murder in particular. There are only three motives. Basically, I think he said it's either money or it's sex or it's a combination of the two. And if you apply that in this case, it's one wonders, which one is it? If you apply it to the Chris Watts case, which one is it? And I don't think you can really ever totally isolate it and say it was only about money or it was only about that. I think it often is, I don't want to say six of one, half a dozen of the other, but a certain proportion, I think it often is of both in many criminal cases. Even the Patrick Frazee case, I think, was a combination of money because he had a loan of $72,000 that was maturing, I think that December. She disappeared on Thanksgiving, so in November. And I think Patrick Frazee was a kind of a playboy as well. So I don't know. I'm not sure to what extent sex played a role, but I think money certainly played a role of some kind in the Patrick Frazee case. So I'm going to read now the conclusions that Judge Lama laid out. We're approaching the 2 hour mark. It's 1 hour 45. I just want to read through these conclusions and then I'll take some more of your comments and questions. And then I'm going to see whether to continue I can carry on maybe for half an hour just going through some of the media coverage of this. And then maybe even going to the first page or two or three of the order. It kind of depends on you guys. So to me, I think to me it's a bit stinky because he's actually been vomiting. It's kind of my fault. The cat doesn't always eat all her food, and then when she doesn't, I give it to him to eat. And I think it's a combination of that and odd handouts I've given him. I think he's got a bit of an upset stomach. So he actually woke me up early this morning. It's now 5 o'clock in the morning here. It's raining outside. But he woke me up this morning with vomiting noises, and it honestly sounded like there was going to be a big stew to clean up and wade through. But it was actually surprisingly little. So, Timmy's not feeling so great. Hey, Timmy, are you okay? Okay. He's not feeling so great. Yeah, I'm gonna just stick to giving him the food that he should be having for the next while. Hopefully he'll be okay. Yeah, schnauzers in particular are better off on doggy food only. I know they say that, but schnauzers are also particularly like bigger type dogs. No matter what you're eating, they want a handout. And I guess I'm a bit of a pushover in that regard. I'm quite stern and strict when it comes to the law and true crime, but when it comes to a doggy looking at you like, are you going to eat that or you're going to eat all of that without giving me anything? You know what I mean? Anyway, so on the last 2 pages, Judge Lama provides his conclusions. So I'm going to read them. Wherefore, for the reasons stated above and in the court's discretion, the court concludes as follows. And he provides 6 points, but some of these points have got sort of sub-points, and some of the sub-points really go on for quite a while. So he says, number 1, the court finds and it's highlighted in bold, a continuing pattern by the people of an inability and failure to comply with its Rule 16 obligations, as well as the court's case management orders. So wrapped on the knuckles, the prosecution of being chastised, kind of disciplined, in the words of that other defense attorney, what did he say? One of the most severe admonishments I've ever seen. So well, this is it. The court finds a continuing pattern by the people of an inability and failure to comply with its Rule 16 obligations, as well as the court's management orders. Number two, the court finds the people's actions amount to negligent and arguably reckless disregard for their Rule 16 obligations and duty to abide by court orders. So the court says there's a continuing pattern of failures. There's a continuing pattern of inability to comply to certain procedures. The prosecution are negligent and they arguably even reckless. That's also highlighted. But then number three says the court does not find, based upon the record, that the people's actions amount to willfulness. So in other words, the court are saying that the prosecution aren't being deliberately mischievous. The prosecution aren't being deliberately stubborn. They're not sort of strategically withholding things. They're not being, what's the word? Their wrongdoing is sort of innocent. It's kind of an innocent mistake, or it's understandable, or it's reasonable. In other words, not willful. They're not intentionally trying to and deliberately trying to and purposefully trying to frustrate the defense. They're not doing this willfully, right? In other words, some of their failures have been just kind of innocent. And the kind of feeling you get is that the defense have been hammering the prosecution and they've given them a huge burden to provide. Like, we need all the logs, we need all of this, we need all of that. And anywhere that the defense can find a failure, they've been hammering the, bear in mind, anyway, they've been hammering the prosecution. And so it amounts to making the prosecution look bad. And then this appears in the media, and the media think, wow, the prosecution don't have a case, the prosecution is weak, the prosecution is flawed, and the flip side, they don't, they don't have a case. Barry's case should be dismissed. Barry's innocent. The charges against Barry are weak, etc., etc., etc. Well, is that the case? Because if you really wanted to argue that the charges were weak or whatever, then go into the merits of the case. Don't argue that you took too long to provide that, or you took too long to comply. Are we arguing the murder case, or are we arguing procedures and protocols related to actually taking the case anywhere? Then number 4, defense requests the following sanctions. So this is what the defense asked for. Dismiss the case, reduce the charges, set a reasonable bond. In other words, reduce the current bond. And I think the bond had already been reduced, but I could be wrong. And reimbursement of attorney fees and costs for time and expense incurred. So the defense is basically saying, based on this negligence, based on all of this, based on this pattern, can you please just throw the case out? If not that, can you reduce the charges? If not that, can you set a reasonable bond? Can you reimburse attorney fees, blah, blah, blah. So they're kind of just saying, as a result of the prosecution messing up, can you throw the case out? And can you reduce the charges? And the court finds the following as it relates to these requests for sanctions. And this is quite interesting. So what's going to happen now is they're going to talk about the sanctions that they've already applied, and then where they say, well, we've done these sanctions, we're not going to do these. So these are the explanations. Goes from A, B, C, D, E, F, G, H, I, right? So quite a few. And then under A, there are also 3 subheadings. So I'm just going to read these through. On March 10, 2022, the court sanctioned the people for their continued violations related to expert disclosures and excluded numerous experts as a result. The court excluded the following prosecution experts. Number 1, Megan Douge, Andrew McDermott, Kevin Hoyland excluded the witnesses as expert witnesses. Kevin Hoyland should actually ring a bell. I think he actually testified in the Patrick Morphew case. I think he deals with metadata. I think he deals like cell phone pings and that sort of thing. But he is with the CBI. I just want to make sure here. Sorry, it's actually FBI agent Kevin Hoyland. And he was in the Frazee trial. He was the cell phone expert with the FBI. So what's quite interesting here is Kevin Hoyland was an expert in the Frazee trial, but in this trial now is not an expert. What do you think about that? Do you think it's valid that he's not an expert? That in one trial he's an expert, in this one he's not? What do you think about that? Corporal Deb says, both my dogs get dry kibble. Winnie and Nelson are rarely sick. Winnie's the schnauzer and I learned quickly. Good luck with Timmy. Timmy is very seldom sick, but he has been eating a lot of cat food of late, including that sort of mushy cat food. So my bad. I didn't really think cat food is really bad for dogs, but it might not be only the cat food. Anyway, let me stay on brief here. So I think it's very interesting, this Kevin Hoyland being excluded as an expert witness when he's appeared in another major case as an expert witness. I find it quite interesting. But that doesn't mean he can't appear as a witness. Anyway, and then there's quite a few others. James Stevens, Kenneth Hicks, Alex Walker, Andy Rorich, Jonathan Grusing, Derek Graham, Ken Harris, not permitted to provide expert testimony, free to provide lay opinions. Whoa, hold on a second. Megan Douge, Andrew McDermott, and Kevin Hoyland excluded the witnesses as expert witnesses. I'm not sure if that means they are allowed to testify. I'm not quite sure, because the next thing says that they not provided to provide expert testimony, but they are free to provide lay opinions. I'm assuming that Kevin Hoyland will testify, but not as an expert witness, but I could be wrong. It could be that those 3 may not testify at all. So I'm not quite sure on that. Some of you may know this case better than I do in terms of those aspects, and also what Lauren Shaft said about them. So I'm not sure about that. But in terms of, I think Ken Harris, I'm just trying to think who it is now. Jonathan Grusing, isn't he one of the agents that interviewed Barry Morphew? So he isn't allowed to provide expert testimony either. That to me is quite worrying. Nisi says, how can you give an opinion but then not be an expert? You are kind of giving almost like a witness testimony. So in other words, you're giving you can do that. You can kind of give your opinion as someone who is related to the case. So in other words, it's not elevated to the level that you're an expert, but it's nevertheless relevant. What you do often find in cases are like a battle of the experts, where you'll have one expert saying something. Often you have it with pathology or DNA or handwriting analysis or whatever, or even maybe a polygraph. You'll have one expert saying this and another expert saying that. And then it's like a war between the experts. It's kind of like a battle between the experts for what is the truth. And so it's often quite funny. So you kind of, there's a sense that some experts are hired guns kind of thing. But I must say, I don't actually know exactly what this means. I don't know how it's going to play out. I mean, you might have a situation where you have someone who the prosecution regard as an expert, but they are legally defined, or legally, in terms of this case, legally regarded as lay individuals, and then that is then asserted in court, and then the jury kind of get told, okay, well, this is a non-expert's opinion on something, and then the defense bring in their expert and they say, well, this is what our expert says, and he disputes that. Oh, well, you got an expert, the prosecution don't have an expert, the jury wins. Just in terms of the optics and just in terms of the general way that is put together. I'm just saying how it could play out, right? Caitlin Rogers may provide expert testimony, but restricted to the four corners of her current report. So that's quite interesting. She's allowed to provide expert testimony, but within a certain scope. So you can see how the defense have succeeded in sort of tying their hands of the prosecution to some extent. On March 30th, 2022, the court excluded other proffered expert witnesses, Mr. Doug Spence, albeit based upon the stipulation of the people. So there they're saying the prosecution withdrew one of their own expert witnesses. Number C, these sanctions on March 10 and 30th, 2022 effectively excluded 11 out of 16 of the people's endorsed expert witnesses. 3 additional experts were excluded on other grounds. The court finds the exclusion of these witnesses amounts to a significant sanction, but one that was warranted based upon the record. So that is quite a hard knock for the prosecution. Even the judge in this case is saying, this is definitely a significant sanction. We've excluded 11 of your 16 expert witnesses. That is significant. But they say it's warranted. D, considering the witnesses this court has already excluded as a sanction for the people's discovery violations, the court does not find a reduction of the charges to be an appropriate remedy. So score a few points for the defense, score a few points for the defense. Well, they don't score in this area. They say we are not going to reduce the charges. We don't think that's appropriate. So the court are actually saying, you know what? These are serious charges against the defendant, and they are appropriate. That is a significant finding in favor of the prosecution. Then they also use the word exculpatory again here on page 19. They say the court is also mindful that the defense is now in possession of exculpatory information which cures much of the prejudice. That's kind of legal jargon to say the court's now aware that the defense have got nothing more to complain about. You now have all the information that you've argued is exculpatory. You've got all the questionable evidence that you think supports your case. You've now got it all, so you can't complain that you don't have what you need. You can't complain that you don't have what you don't have. You've got what you need. You've got what you have. And then they say it cures much of the prejudice, meaning much of the opprobrium from the defense, much of the unhappiness of the defense is now sorted out by the fact that you've now got everything that you need. because the court did not find willfulness on the part of the people, dismissal of the case is beyond this court's discretion. Great. So basically they're saying the defense accused the prosecution of purposefully kind of being mischievous and kind of being underhand and kind of being, the bad guys, willfully withholding information. And the court says, no, we don't see it that way. If they made a mistake, they did so innocently. This is the prosecution. And so we're not going to dismiss the case. And and so they're not, it's not in their discretion to do that. Then if the court does not find reducing Mr. Morphew's bond is an appropriate sanction. So it's victory for the prosecution and another one and another one. So in 3 in a row, the court does not find a reduction of the charges to be appropriate. The court will not dismiss this case. The court does not find that reducing the bond is appropriate. Even reducing the bond, that's something they're not going to do. In other words, what the court is revealing here is that they actually feel that this is a serious case, that the charges are serious, that the charges are warranted, and that the trial and the way that it's been presented, besides the witnesses, is appropriate. It's not too severe, it's not exaggerated, it's not unwarranted. It is, it is, as far as they're concerned, it's right, okay? Then you go to G. Regarding the IA file is denied. I think IA refers to internal affairs. I could be wrong. I'm just guessing here. And I think that's the file dealing with Cahill, but I could also be wrong about that. I'm just making an assumption here based on a casual reading of this. Anyway, G, regarding the IA file is denied relating to any request for sanctions as the people did not have constructive possession of the file. Regarding the IA file, this is 17C, is denied relating to any request for sanctions as the people did not have constructive possession of the file. I don't know if that's a typo. Sorry, that's G again. H is regarding the Range Rover data is denied, but the court does find the people failed yet again to comply with the court's disclosure deadline related to the data. And then the final one here is, as to the motivation behind removing Agent Cahill from the case, the court does not find a discovery violation. However, the defense is free to inquire about it at trial before the jury. So you kind of have the defense making a big brouhaha about Agent Cahill. Why was he removed? What did he say? What is this intrigue? It's almost like, let's have a separate trial. Let's have a separate investigation into Agent Cahill. Is this guy credible? Is he trustworthy? Can we believe law enforcement if this dude who was involved in law enforcement did X, Y, or Z? Can't we throw away the whole case because Agent Cahill did X, Y, and Z in his personal capacity, kind of thing? No, you can't. The trial's going to go on. But you can talk about this in front of the jury if you like. And you kind of had something like this in the O.J. Simpson case with the lead investigator there. I don't know if you guys remember. Other conversations he had, etc., etc. Anyway, the final point is the court concludes additional sanctions are not appropriate at this time, meaning additional sanctions to the prosecution are not appropriate at this time. I don't know whether the defense are going to let this slide, and between now and the trial date, it's going to just be like plain sailing, and then the trial is going to start in 3 weeks, or whether the defense are sort of in a situation of, on your marks, get set, go. The the judges ruled the following. Now let's try and find other motions to dismiss. Now let's launch a final, like our best card trick yet, or our best motion yet. Let's ask for this or let's ask for that. One wonders whether there are going to be more motions over the next 3 weeks, or is this the final straw? In any event, the judge sort of goes on to say, this order will serve as the baseline for future orders related to discovery violations. So that seems to kind of cover over if the defense do say, whoa, wait a minute, we found another discovery violation. Whoa, here's another motion to dismiss based on that. It seems like the court has kind of said, you know what, if you're going to come up with other stuff, this is really the baseline. This is going to sort of deal with that almost in an anticipatory way. And then the bottom line is that the case is set for trial to begin on April 28, 2022, which is 20 days since this was ordered on Friday. And it is really not far from now. It's 3 weeks away, less than 3 weeks away, 18 days away. So ordered this Friday by the court, Ramsey Lama District Court Judge. So in conclusion, Barry's defense, I think, have done a fantastic job raising doubt, making the prosecution look bad, and heading into this trial appearing to be the better, stronger, and more organized counsel. But will those optics essentially be enough to win the legal arguments? When they're in front of a jury, are those optics going to continue to shape the case? Is there going to be this continued impression that that the prosecution don't have a case, that Barry that Barry's actually the victim in this? Are those optics going to stay in the court's mind, in the jury's mind, in the public's mind, even in the media's mind, right? I see there are almost 300 of you still in chat, so I kind of don't want to end right now. I do want to take you through a Fox 21 article, not through all of it, but just through some of the highlights of it. I'll put a link to it in chat. Just a really good article summarizing a lot of this quite briefly. It's written by Paige Weeks and it was published on the Friday. Sharon Lynn, who used to be Sharon someone else, but thanks a lot for that, Sharon. I love your emoticon there. I'm actually not on a swivel chair. When I'm on my other computer, I can actually do that. So the article opens up saying, in response to multiple motions by the defense to dismiss Barry Morphew's case, Judge Ramsey Lama declined the request. So that's really the bottom line, is the fact that the defense have been trying again and again and again just to avoid trial, just to avoid this case actually, being heard, being argued, and thus far they've failed. Now, there is a chance that between now and the 28th, there might be further motions. I really think that ship has sailed. I really think that now you really want to start preparing for your trial. The defense have won some significant territory. They've gotten 11 witnesses excluded, or they can't testify as expert witnesses. They've definitely succeeded in certain areas, but they've failed in the most critical areas, which is the case is going to trial. The charges haven't been dismissed. The charges haven't been reduced. So even Barry may think, wow, my defense are doing a good job, but they didn't succeed in a critical area, which is, like this argument that Suzanne wasn't murdered. This isn't a murder case. In other words, where we are now, right now, based on what Judge Lama said, is this is a murder case. We need to find out whether Suzanne Morphew was murdered. And so it's going to criminal trial, and the charge is Barry Morphew is charged with first-degree murder, and now those charges will be tested, argued, and a jury will decide on them, right? So the article goes on to say Barry is facing charges of the murder of his wife on the Mother's Day weekend of 2020. That's quite an interesting way of putting it, because it's not actually clear if she was murdered, when she was murdered. Was she murdered on Saturday or was she murdered on Sunday? I must say, for a long time, I actually assumed that she disappeared or died on Mother's Day, and it actually appears that she died probably Saturday afternoon, in daylight, like, mid to late afternoon. The article then goes on to quote from the court document, which I've already done, talking about it's not going to apply additional sanctions. The article talks about Morphew's attorneys arguing that the claim of murder was false. There were false claims of confessions and documentation. So the defense, according to this article, they're saying, claiming that this is murder is false. The court and the judge is saying, no, it's not, it's appropriate. Claims of confessions, not quite sure what that deals with, is also false. Barry did make 15 or 16 statements. He certainly never confessed really to anything, but he did admit to knowing certain things and doing certain things. I'm not sure if it's got to do with that. Not really sure. I don't know whether he made confessions to, as far as I know, he didn't make any confession. So I'm not quite sure what that's about. But this is quoting from the article. There is no evidence of a murder, certainly no evidence that Mr. Morphew committed a murder. It has been well established and confessed by the prosecution that there is no body, no confession, no eyewitness testimony or physical evidence that Ms. Morphew, that Suzanne Morphew is dead, was murdered, or that Mr. Morphew is responsible. It's quite a strong argument. It's quite a well-worded argument. It's quite a convincing argument. But I don't know if it's true to say that there's, I suppose it is true to say there's no I suppose it's true to say there's no physical evidence that Suzanne is dead. But I think there's a lot of circumstantial evidence that Suzanne Morphew is likely not alive. For example, that she has not used her phone at all, her social security, her own money, and the circumstances, the context when she was last heard of. The article goes on to say, talking about this, the defense complaining about how they got the discovery, when they got it, and that was an issue. And also that the discovery contained untrue statements from the telematics expert, Kenneth Hicks, the forensic computer expert, James Stevens, and the expert in cell phone tracking and historical call data analysis. He was in the Patrick Frazee case, Kevin Hoyland. So the defense attorneys were saying there were untrue statements in there. So now I'm going to read from Lauren Schaaf's tweets. She says, Judge Ramsey Lama files an order to have Barry Morphew go to trial for the first-degree murder of his wife, Suzanne Morphew, despite a pattern of violations from the prosecution. So in other words, the prosecution did mess up. but not to a high enough level, to a serious enough level to scupper the trial. The court has sanctioned the prosecution by not allowing 11 of the 16 states' experts to testify, and then she lists them. The court will exclude prosecution witnesses Megan Douge, Andrew McDermott, Kevin Hoyland, James Stevens, Kenneth Hicks, Alex Walker, Andy Rorich, Jonathan Grussing, Ken Harris, Derek Graham, Doug Spence. 3 additional experts were excluded on other grounds. I don't think that means none of those people will testify. They just won't testify as experts. And I think especially the testimony of Grussing being excluded as an expert is a bit of a blow. Ken Harris possibly as well. I'm going to just skip through some of the rest. Lauren Schaaf refers to the following discovery violations: mirror copies of the iPhones, past court deadline; spy pen recordings, didn't provide the enhanced version. So they provided the recordings, just not that advanced version. So once again, is this willful? Is this the prosecution purposefully not helping the defense? Are they being unprofessional? Are they actually, is it like really, really serious? And I just wonder whether do the defense really feel that the prosecution have been misbehaving, or do the defense want the impression to be created that the prosecution haven't done what they're supposed to do? And there's a kind of a difference between those two scenarios. Suzanne Morphe's iCloud account 5 weeks late. That is quite serious, because that is something that they would definitely want. 2 laptops and the Kindle. There's a discrepancy between the state and defense attorneys. I'm not quite sure what that refers to. Is it the data from those things? I'm not quite sure. Then it concludes, still the court ruled it did not find the people's actions amounted to willfulness, as I've said. And then that's the end of it. The jury trial is scheduled to begin April 28th. So that's a very light version. That's kind of a very vanilla version of what I've just taken you guys through for over 2 hours. Hopefully I've provided a bit of insight and background and context and a little bit of expertise related to other cases and what we're really dealing with here, especially based on a recent reading of the affidavit. If you haven't read through the affidavit, if you don't know it sort of off by heart, not saying I know it off by heart, but I certainly know it, it's fairly fresh in some of your minds and in my mind, then you can see how it is quite a strong case that the prosecution have, that law enforcement have kind of compiled. Let's look at your comments here. The jury will see something. Jody says, great summary. Thanks for that. Sharon Lynn says, very interesting. Appreciate that. Yvonne Phillips says, those kind of mistakes are unfortunate, but it gives the defense ammo to make the prosecution look wobbly. A lot of law, certainly in terms of the courtroom, but also documents that are sent to clients or to offenders, or whatever the word is. A lot of the law is theatre. A lot of the law is I can't put it in a better way. So something I actually said is, if there's staging in this crime, are you telling me a trial can't be staged in a certain way? And a trial isn't theatre of a certain kind as well. So much effort goes into presentation, into how your defendant is dressed. He must always be dressed impeccably in a suit. His daughters are well dressed. They always seem to be supportive. They're always at his arm. It's not like one day he arrives and one daughter's not there. Every single time he's there with both daughters. So every single time you're getting the sense of they believe in him, they are with him, they support him. So who are you not to? And over time that works on your psychology, where you think his daughters love him, his daughters know him. What do we know? You know, that sort of optical psychology works on your psychology over time. He looks like such a nice guy. He's dressed so nicely. Why would such a well-dressed, whatever man do something, right? Sometimes it's really done overboard. You'll have a defendant arriving at court in a wheelchair or appearing ill, or they're wearing spectacles, they're wearing glasses, all in an effort to make them appear, does this look like a murderer? You had Jodi Arias, her hair color changed. She was wearing glasses some of the time. Chris Watts was also wearing glasses. You didn't see him wearing glasses on the Sermon on the Porch kind of thing. Sometimes this is calculated to solicit sympathy and a different impression of your defendant. Jody says, do you think Barry will take the stand? That's a great question, Jody. Let me put this question into chat. How many of you guys think Barry will take a stand? Yes or no? Let's see what you guys say. So I'm going to ask two questions. The first question is, do you think Barry will take the stand? So Diana says no. Teresa says no. Living says yes. The Crypto Zoo says no. One More Dime says no. Thought Criminal says usually they do, but not John Barry. And then there are quite a lot of no's here. Wendy, no. Sharon, no. Terry Dean, no. Jean Karras says no. Zircon, no. Susan, no. Status Quo says no. And many of you also say no. Jody also says no. Pauline Buckle says no. Nisi says yes. Verbal Constipation says no. Heavenly Clouds, no. Speedy McWeenie Mom, no. Alley Cat, no. Strawberry Wine, no. Well, so many. Danielle Lee says, I think he would want to, but his lawyers won't let him. Good answer. Wendy Howard, no. Jamie, ML, no. Leah Simpson says, I wish he would, but not likely. Patricia Burns, no. Teresa says Barry won't. Stephanie says no. Miss Rita says no. Marilyn says absolutely not. Kathy Mims, no. So, how am I going to answer this? Do I think he will take the stand? No, and I say no because I think his lawyers will not want him to take the stand. And I also think so I think he won't take the stand, and I think his lawyers will try and persuade him not to take the stand. On the other hand, I don't know whether he will want to testify because he participated so eagerly, so repeatedly, so I don't want to say effortlessly, but so casually. He spoke so often in those 15, 16 statements over the course of a year to those agents, and those weren't the only statements that he made. Something else that's also quite interesting is Barry Morphy was asked, I think in April 2021, to take a lie detector, and then I don't know if he said no, but I think he said, I'll think about it, but I don't think he ultimately did. So you can ask, you can put the question, did Barry Morphy take a lie detector test? Was he asked? Answer, answer, he didn't take a lie detector. That's as far as I know. And so you can apply that. He didn't take the lie detector. Would he go into court where they're going to test him for, are you telling the truth? Is this true? But you said this, but you said that. Would he be willing to do that? I think that's quite an interesting way of putting it, but Barry hasn't really spoken to the media. Here and there he did, but I kind of think that he would probably feel at times that he would really want to, what's the word? He would want to testify. If I was his lawyer, I would say that's a bad idea. It will help the prosecution, I think, if he does testify. There's also the possibility that Barry may insist on testifying. He may say, I've got to, or he might believe quite strongly that, I can explain, and maybe can convincingly. Maybe he may feel the jury trusts him. He might feel he wants his chance to talk to the jury. And Barry's quite a charming guy, and he's quite a good-looking guy, and I think Barry kind of believes in himself. That's kind of the strongest thing. Barry is quite a confident chap, so he might kind of insist. And what can his lawyer say if he insists, right? Overall, I don't think he's going to testify. And I think if he doesn't testify, I think that in itself is an interesting scenario, because in the Casey Anthony case, Casey Anthony didn't testify. In the O.J. Simpson case, he didn't testify. In the Chris Watts case, even, he didn't testify. In the Patrick Frazee case, he didn't testify. Now, you can say what you like about whether in those cases those defendants are guilty or innocent, but the fact is, in those cases, some people were found guilty and some were found innocent, right? Casey Anthony didn't testify. She was acquitted. O.J. Simpson didn't testify. He was found not guilty. I'm not sure if it's true to say Casey Anthony was acquitted. She was found not guilty. But Patrick Frazee didn't testify and he was found guilty. The Patrick Frazee case was really interesting because he had a really, really long prosecution. The prosecution did all these different things. The defense cross-examined and did their thing. And then when the prosecution was done, when the prosecution had led their case, the defense basically didn't lead any witnesses. No one testified. It was like prosecution and the defense were like, well, we don't really feel we've got a burden to meet. There's no body, no crime. We don't need to do anything. The defense rests, and it wasn't enough. And Patrick Frazee was found guilty. That's not going to happen here. You can bet your bottom dollar that the defense are going to lead witnesses, that they're going to mount a huge challenge, but they've also got a huge challenge facing them. The affidavit alone has a lot of questions in it. The affidavit alone just is a compelling narrative on its own. The circumstantial evidence in this case is not easily dismissed. Joan White says something there. Someone says, I see Timmy's paw. Do you see this paw? Now, Timmy's lying here. Can you hear the rain outside? Jeff Merklin says the only time you surely put the defendant on the stand is self-defense. Jury has to hear from the defendant on that. Otherwise, the dude better listen to his lawyers. Okay. I'm going to tell you an interesting story. In South Africa, Henry van Breda was on trial. I actually wrote a book on it called Indefensible. I was just like, he's not going to win this case. You sort of wondered, does he know that? And he's quite a clever kid. He was about 23 or something when his trial was heard. He was on trial for triple axe murder. Quite a clever kid, a kid of millionaires, a kid of wealthy parents. Quite a good-looking guy as well. Quite a charming guy. And the biggest defense that Henry kind of had was, you looked at him and he kind of had this baby face, and he seemed like a soft, sweet, gentle, nice guy. He was very likable. His best defense was that you looked at him and you just thought, there's no way this nice kid could have done that to his own family. Except that the evidence was overwhelming, except that there was a 911 call where he sounded sort of drugged or whatever, but he just sounded not right. He sounded kind of sleepy. Anyway, I wrote a couple of books on that case. The first one was Indefensible. And I kind of, I guess, provoked him. I kind of said, there's no way you're going to win this case, but maybe you've got a chance of winning it if you testify. And what was really interesting in that case was the defense started off by not calling him to testify first. And I'm not quite sure what the protocol is in America, but in South Africa, a lot of law systems are based basically on the same structures. But in South Africa, if you're accused, as we call them the accused here in America, the defendant, if your accused is going to testify, he's got to testify first. He's got to give his version without the benefit, or this is just generally how it's done. He's got to testify without the benefit of all the evidence being led, because there's a sense then that if he testifies at the end, that, well, he's able to customize, integrate, tailor his testimony so that it kind of incorporates all of the information, including from the prosecution and including from his own witnesses. And so in Henry's case, he did ultimately testify, but he testified, instead of testifying first, he testified much later. And that is something that prosecutors and a judge will frown on. They'll say, if you're innocent, why do you need this cautious approach where you first want to kind of have a record of what your own experts are going to say? Why would you do that? If you're so confident in your client's innocence, why wouldn't you just put him on the stand and he's going to be able to withstand anything? And so in my first book, I kind of wrote, and I sort of directed this at Henry. The last line of the book was, "Are you a man or a mouse?" Because, and I put that sort of stutter there because Henry did have a slight stutter, and then Henry did testify. There's more intrigue to that story. You'll have to read the other books to find out about it. But I kind of challenged him to testify. He did testify. And he failed. He failed to convince the judge. There was a moment in the first day where it seemed like he'd sort of put up quite a good testimony. And then the judge asked him something. The judge was quiet the whole time. In South Africa, we don't have juries. The judge was quiet throughout his whole testimony, and then he asked something and felt like the judge seemed to be expressing reservations or doubt. And then suddenly that feeling you got of Henry winning momentum, Henry being persuasive, kind of fell flat, and that was how that first court day ended. I just thought that whole thing was really interesting. But that was a case where the evidence was overwhelming. In this case, I wouldn't say that. I wouldn't say it's that overwhelming. This is a fairly strong circumstantial case. Henry van Brda's case was a very strong case from a prosecutorial perspective, and even so, they weren't able to. At the end of the case, the judge still said, "We find you guilty, but we still have no idea why you did this. We still have no idea what the motive is." And so I wonder whether in the Suzanne Morphew case, if motive isn't essential to communicate in a trial. It's not you don't have to give a motive. But in terms of a jury, I think it's very helpful to give them a reason for what the mechanics were in terms of the psychology behind the intention. You do have to prove intention. You don't have to prove motive. But I think it was a big mistake in the Henry van Breda case for the prosecution not to try and figure out a motive, because the judge wasn't happy with that. Regardless, he did sentence Henry and convict him. But the same actually happened in the Oscar Pistorius case, where a motive wasn't provided. Intent was provided, and they thought that was enough, and I don't think it was. That was a major failure, I think, in the Oscar Pistorius case. In any event, I think it's going to be very interesting. It looks like this case is going to trial now. It's officially going to trial. So I'm looking forward to daily coverage of this. What was said each day in trial, what are the insights, what was that day a victory for the defense or the prosecution, where is the case headed? And although there's not a terrific amount of interest in the Morphew case, certainly this channel's got a fairly modest following in terms of that. I'm interested in it. I'm passionate about it. I really enjoy the trial aspect, and I haven't been doing it for quite a long time. It felt like a really long time since I've covered a new trial, so I'm really looking forward to it. It felt like the Letitia Storr case was going to be there imminently, and that sort of hasn't happened. So I'm really looking forward to that sort of coverage day to day. It is exhausting. It is exhausting to sort of be on it every single day, but that is what I'm going to be doing. And so that's something to look forward to at the end of this month going into May. It may be a 3-4 week trial, so it's going to be quite a lot of coverage that is just going to be Barry Morphew. I'm also kind of looking forward to that. I'm looking forward to, I feel like my content on this channel has become quite fragmented. If I'm not talking about the Ukraine war, I'm talking about the Summer Wells case. If I'm not talking about the Summer Wells case, it's the Gabby Petito case. If it's not that, it's the Chris Watts case. And to be honest, I don't like that kind of coverage. I don't like that kind of fragmented coverage. I like to get totally immersed in one case where you become very, very familiar with the people, with the circumstances, with the fabric. And that's when you get the real value, the real meaningful analysis and the narrative. The narrative really achieves a sort of a richness, and so I'm looking forward to that. I'm looking forward to focusing on the Morphew case, and so it looks like we're heading in that direction. Nisi says it's difficult to jump around. It's not just that. It's just it's not that it's difficult to jump around. It's just that tends to lead to superficial analysis. I mean, another case that I wouldn't mind, and I might just look at a little bit more deeply, is the Amanda Knox case, some of the statements she's made recently. But the more you jump around, the shallower your analysis is of each case that you look at. And the longer you can the more time you can consistently spend in one case, the deeper your understanding is of the case and of what happened. And that is the true crime that I want to be providing, right? That's where true crime rocket science roars into its own, comes into its own. It is also an interesting question, will Jeff Libler be on the stand? That's also going to be very interesting. Leah says, I'm anxious to see the daughters testify. Also a very interesting scenario. Will they testify? A case that's somewhat similar to this, again, from the South African perspective, Jason Roder, he said that his wife committed suicide. He was found guilty of murdering them, but then he had 3 daughters. And there was talk that they were going to testify. They seemed to be supportive of him, and ultimately, if I remember correctly, I don't think they did testify. So also quite an interesting case. Hey Jealousy says, some cases I don't want to study. I love Van Gogh. So I must tell you, the 15th episode of the Van Gogh finale is probably going to be the most powerful, the most compelling, and the most interesting, because we're going to be dealing with some of the most dodgy stuff regarding the gâchets, the possible murderer, even murderers of Vincent van Gogh. So we're going to be dealing with the dodginess, the dodgy allegations and the dodgy rumors surrounding these people in detail in the 15th episode, 15th live stream. So look out for that. Nisi says, can't wait. I was actually going to do that now. That would have been this live stream, but obviously the Morphew news is more topical and more kind of important at the moment. See, Timmy's paused. Timmy's like, can you shut up? I want to do something. Jody says, Jeff could be the prosecution's wild card, private conversations with Suzanne. You can understand that Jeff will probably want to not be, he will want to be almost as discreet as he can be. Jeff had an affair. As far as I know, he's still married. What are his children going to think of him, kind of thing. So Jeff is probably not going to want to say any more than he absolutely has to. But what is interesting in the affidavit was, I think they asked Jeff what he thought happened to, they asked Jeff what they thought, what he thought happened to Suzanne, and he sort of didn't mince words. He was quite specific and quite unambiguous. Bridget Bowman says, I can't wait till episode 15 of my favorite Van Gogh. I was about to catch up on episode 14, then saw this coming up. Something to look forward to this evening. Bridget, why are you not a member? Because we want your conversation. You must become a member. Terry Dean says, Libler will not want to jeopardize his family life. Yeah, I mean, Jeff Libler didn't come forward. The authorities figured out who he was and found their way to him. Something like, if Suzanne disappeared in mid-May, then it was like June, July, August, September, October. Around about 6 months later, they only got hold of Jeff Libler. Not because he came forward, because they finally figured out the Morphew marriage wasn't so happy, wasn't so perfect. Suzanne herself wasn't this sort of perfect partner. And I mean, who is perfect? And then they spoke to Jeff, and then this other side to Suzanne came out. I think for a long time people may have assumed Barry was having an affair dot, dot, dot. And so I think it shocked those following this case that it was like Suzanne had an affair. But I still think the question remains, did Barry have affairs? Also, was Barry having an affair? And also, I think one of the biggest questions the prosecution need to emphasize is, did Barry find out Suzanne was having an affair? Also, when did he find out? And what did he find out? I think those are definitely quite interesting questions. And also, this idea of, if Barry found out, how could he have responded? What is Barry's pattern for, like, how does he react or respond to certain other things that could be upsetting? What kind of person is Barry, right? Diana McKinn says, this will be my first true crime rocket science trial coverage. Looking forward to it as well. I did cover the Patrick Frazee trial kind of in detail, but I also wrote a book about it, so it's a little bit different. I'm not writing a book about the Morphew case, but I will be covering every day's news, and that will kind of amount to a narrative on its own. A trial is a contest of competing narratives. Which one is more compelling? Which one is more anchored in the evidence? Which one makes sense at the end of the day? Which one is the most realistic? Which one is the best at answering the question, what is real? What really happened here, right? Someone asked, how's my rib cage pain going? Right now, absolutely fine. I'm not sitting here with any pain, any discomfort. There's just a slight tightness. My sore throat is, I'd say, 80% gone. I wonder if I can show you. Timmy, can I put you down? If you want to see the scar on my arm, for those interested. So I fell on my left shoulder, but I also fell on my arm. You can kind of see the wound is almost completely healed. So this was actually almost like a brown-black color. That was like a scab that was like almost completely black. There was no bruising whatsoever, but there was a lot of skin that was taken off here, and it's almost completely healed, which is quite amazing. Sharon Lynn says, is this week 3? I think it's week 2. It's maybe 2.5 weeks. So I fell on, or am I wrong? I fell on the 21st, so it's 1, 2. I fell on the 21st, so it was one week. I guess it is about 3 weeks. Is about 3 weeks. Feels shorter than that somehow. Okay, so I'm going to sign off now. We're at about 3 hours. I might be going through the rest of the document, maybe Monday or Tuesday. I'll be taking you guys through some of the highlights from the rest of that 20-page document. We touched on fairly lightly here, believe it or not, but I'll touch on some of that other stuff. I just want to thank the mods that are here. Has Stephanie gone to bed? Sharon Lynn is here. I don't know if Stephanie's still around. Well, we haven't seen Bria for a while. But thanks a lot to is Jean Karras still here? Thanks a lot to the members that are here, Thought Criminal, Nisi, Yvonne Phillips, Hey Jealousy, Terry Dean, Susan Becker. Am I leaving anyone out? Thanks to all of you guys. And then also thanks a lot for the super chats, always appreciated. Terry says, very glad to see and hear of your healing. We greatly appreciate your valuable time, night and day. That is true, to help us sort this all out. And then also to the subscribers. I sometimes miss our subscriber-only chats. But yeah, we'll definitely be having more of these. But I've got a feeling, don't be upset, but I've got a feeling during the trial we might be down to members only, just because I'm anticipating a lot of chatting, a lot of interaction, and it's just going to be difficult to manage. So we'll see what happens. I might do every fourth or fifth one subscribers only, but there probably will be quite a lot of members only trial coverage. But there will be a lot of overall trial coverage anyway. Janet Babb from Canada, thank you very much for that. Appreciate that. Looks like you've got a chipmunk that's sort of going, thank you. Patricia Burns says, thank you, Nick, and thank you to all of the great people in chat. I must say, I don't think I saw a single message in chat where I thought that's nasty or that's unfair or that's unacceptable. So thank you to you guys for just, being interested in a way that is decent, considerate, kind, intelligent, the way we want to be as a true crime community. Meaningful. We want to have meaningful conversations with one another. So thanks, everyone. Someone says, sorry for the tantrum. Well, if there was one, I missed it. Just some of the final comments here. I'm just counting down to 3 hours. Susan Becker, thank you very much. That's quite a cool sticker there, or little animation. What does it say? Number 1. Okay, cool. Is that a fox? Thought Criminal says the last one I followed was Arius. I do wish this one was being broadcast. I must say, when are we going to get another trial that is going to be broadcast? There was the Durst trial, but Durst sort of looked like a corpse, and then he did die shortly after that. So it's so weird how the Durst trial could have, given what it was all about. I mean, billionaire's son should have been a super, super, super high-profile case and was sort of fizzled. What's also interesting is how the Summerwells case has come up, and you had the Gabby Petito case coming up within the timeline of the Summerwells case, took the world by storm, like really exploded, and then sort of went away, and it's almost like the Petito case is now dealt with, and there wasn't even a trial, and the Summerwells case hasn't even been concluded yet. So it's interesting how you have these gyres and timelines and conveyors and sort of corridors, and how some cases skip nimbly through that. They sort of burn fiery and then they disappear, and other cases drag on and nothing seems to happen. The Chris Watts case sort of was one of those that sort of was like a meteor shower. Everything happened very, very quickly. And then regardless of the creator's commentary today, that case was really done and dusted in record time. This case is, I think you could say, fairly reasonable time scale. We're at the 2-year time part of the timeline in terms of the prosecution, and now at last it's going to trial. There's so many other cases that aren't there yet. The Daybell case, Chair Daybell, the Letitia Storr case, the Summer Wells case, and so on and so on, you know. "30 seconds remaining. Nisi says so many cases. I mean, there's also the Alec Baldwin case, what's happening there. You know, things have gone really silent over there. There has actually been some developments there, but I've just not really gone into them. Patricia Byrne says, imagine a time when no new cases arise. Well, I hate to say it, but if things really go worst case scenario in Europe, you may have a scenario where there are no new cases, where that is our reality, our common reality. And don't think of that as not crime. A war is not separate from crime. A war is the granddaddy of all crime. It's the same thing. Things are covered up. There's misdirection, all sorts of things. Control of the narrative, PR, attack, defense, etc. A lot of wars are prosecuted afterwards in court, like the Nuremberg trials and all that kind of thing. That's also something I want to cover, but people don't seem to be interested in it. You know, the Ukraine war from a true crime perspective. So there's really a lot to talk about. Okay, so that is it. Thanks, guys, for being here. There have been almost 300 of you present for 3 hours. So thanks a lot for joining me. I hope to see all of you again in 3 weeks, but I'll obviously be keeping you up to date between now and then. Take care. Again, thanks for the super chats. Thank you to all of you, and I'll see you guys again next time. Okay, enjoy the rest of your weekend.